Representative Stafstrom.
Thank you, Mr. Chairman, and thank you, Justice McDonald. Congratulations on your nomination, and thanks for bearing with us for the better part of the day here. I want to start by asking you about something I don't think we've covered yet today, and that's your role as the chairman of the Criminal Justice Commission. It's a role I believe you've held for the last year or so. Can you inform the committee what the Criminal Justice Commission does?
Well, it's probably been 8 months, but the Criminal Justice Commission is statutorily required to hire the chief state's attorney, the 2 deputy chief state's attorneys, and the various state's attorneys for the various judicial districts around the state, and also is responsible for the reappointment of those state's attorneys when their terms are up. Additionally, the Criminal Justice Commission is responsible for vetting and selecting assistant state's attorneys to fill vacancies amongst the ranks of prosecutors when those vacancies are filled.
Does the Criminal Justice Commission have any administrative responsibilities with respect to the various state's attorneys' offices?
Not the statute creating the commission is relatively narrow. The primary administrative responsibility is the vetting and review and approval of the positions I've just talked about. Let me say, if the commission hires assistant state's attorneys, then they are hired and they go into the service of the state. They never come back before the commission. They work for the state. They work for the Division of Criminal Justice, and they report to the state's attorneys who are overseeing their judicial district. But the chief state's attorney, the 2 deputy chief state's attorneys, and the various state's attorneys are appointed and reappointed based on any criteria that the Criminal Justice Commission deems appropriate.
But have you had a chance to review or comment on any of the policies or procedures of the various state's attorneys' offices in that role?
So, in a limited way. So, I was the position for members that don't know, the position is a position appointed by the governor. It has historically, at least as long as apparently anybody can remember, been held by a member appointed by the governor from the Connecticut Supreme Court. I am now the chairman. Justice Palmer had been the chairman for 8 or 10 years. Prior to that, Justice Sorello had been the chairman for 8 or 10 years, or lengthy periods of time. So when I was appointed, I think it was back in June, the timing was, let's say, not optimal in the sense that I and 2 other new members of the commission were appointed just a couple of days before we had to reconsider the nomination of 7, I believe, 7 of the state's attorneys from around the state, pretty much half of them, and so we had literally, because of the timing of the nominations, we had a very limited amount of time to interview and evaluate them, but because of I think the members of the commission thought that because of the limited time, it would not be appropriate for us to inject any kind of new criteria for those evaluations. And so we interviewed them. It took a lengthy period of time, and we had an opportunity to question them about their offices, how they manage their offices, what their training is like, and that type of thing. And it was very illuminating. And ultimately, we reappointed one of the deputy chief state's attorneys and all of the state's attorneys who were up for renomination at that time.
What do you mean by illuminating? Were there any deficiencies in the process or the like that came to your attention?
Well, so a couple of themes were developed in our questioning, and coming from a private law practice, I asked all of them, could you show me, what's your management plan? Could you show me your management plan? And nobody had ever asked them about that. Nobody had ever expected them to have a management plan, and so not surprisingly, none of them had a management plan for their individual offices, in terms of how they staff their offices, how they prioritize the work of the office, how they can train and encourage and create career paths for advancement within their offices. It was effectively done on an ad hoc basis without a plan in place per se. And there were other members of the commission who were very focused on the fact that there are concerns about specific ethical considerations for prosecutors that are not covered under the rules of professional conduct. Many states have adopted the National Association of District Attorneys guidelines on specific ethical considerations for prosecutors, because there's some very unique considerations for how prosecutors deal with victims, how they deal with witnesses, how they deal with situations where defendants are testifying against each other, and there's no uniform ethics manual or procedures within the division. So we started having a conversation about the need to start to develop those types of tools, and I volunteered to assist them in that, and I worked with the dean of UConn School of Business, who was very generous and said he and his team would make themselves available to the division to start helping the state's attorneys to develop those management plans, not necessarily for the commission, but for themselves, so that they could run the best operation that they could on behalf of the division.
And I think that's critical. I'm glad you highlighted that, because I think, you talked about this very early in your testimony. I think it was probably 10 o'clock this morning or 10:30 this morning. But really the distinction between the job you interviewed for before this committee 5 years ago and the job you're interviewing before this committee for today, which is the distinction of being the head of a branch of government and an administrative function. And so I guess, would you agree with me that sort of in sort of pushing for management plans, you were looking for the state's attorney's office to figure out how to maximize its work and maximize its resources with the limited resources that clearly are available to it today?
Yes, I mean, the division, like all agencies within the state, is very challenged right now. I think they are down 20%, if I recall correctly. The number of prosecutors, they're down 20%, and it presents unique challenges. I know one state's attorney who told me, because of staff shortages, it's not unusual for that state's attorney, who is the top law enforcement official in his jurisdiction, he oftentimes spends a day or so or more doing traffic court, because there are not enough prosecutors to do all of the work that they need to do. There's no way that with all due respect to the prosecutors who do traffic court on a regular basis, there's no way that a state's attorney's time is best utilized in that way. And so in my view, in a very constrained financial environment, a management plan would assist them. And I think when we had this conversation, to be clear, I think 2-1, every single one of them thought it would be very helpful, but that there had not been an opportunity for them to learn how to develop those management plans, which is why we reached out to UConn to try and do it as much as possible with no funds that don't exist.
Would pushing for and encouraging other departments within the judicial branch to implement and review their own management plans be something you'd be interested in doing if you are fortunate enough to be confirmed as Chief Justice?
I think yes, I think any organization, whether it's governmental or private, needs to always be reevaluating what it does and how it does it. I'm not suggesting what I testified earlier was a management plan, but some of the initiatives that the judicial branch is undertaking in terms of trying to do more cases for small commercial or consumer loan cases or traffic cases was intended not only to make the system more efficient for the users so that they don't have to leave court, but so it would also free up resources within the branch because our resources are very constrained. So if you can develop some of those technological developments, that would provide an opportunity to use scarce resources in other ways. I briefly alluded to it. It wouldn't be for the judicial branch to determine, but if we had all of that centralized infractions online, where dispositions could be done online, you wouldn't necessarily, if the division would do it, you wouldn't necessarily have to have prosecutors in every courtroom for a day looking at a sea of people who are losing a day's pay or an hour's pay, right? A lot of people who are coming in are being paid on the hour, and if they're not at work, they don't get paid at all. So it would allow for better access for the public, and it would also potentially allow the division to consolidate into a smaller working group the number of prosecutors who are needed to process all of those infractions.
And one of the other tenets you mentioned first thing this morning was following up on the work that former Chief Justice Rogers has done on transparency. And we've talked at length on this committee sort of about various roles in the court and who plays what roles and the like. And I think ethics guidelines are important, and making those ethics guidelines public and transparent so that the public can see them. It sounds like that's something you've encouraged the Division of Criminal Justice to do. Is that a level of transparency? Is that something you'd like to see the branch do moving forward more generally?
Yeah, well, first of all, I need to correct something if I left a misimpression. The division had begun to work on some ethics policies and procedures, but the effort stalled several years ago and got overtaken by other pressing business. So I don't mean to say that the division was never focused on ethics. They certainly were, and I think they try as much as possible. What the commission was trying to do is to reinvigorate that process. But to answer your question, yes, I think every branch of government should be focused on ethics to the greatest extent possible, in part because of the transparency aspect to it.
And certainly, I think that's an important point, and that's an important skill that you would bring to this committee is this position is understanding. One of the greatest tools you would have at your disposal is the bully pulpit. Not so undifferent than you did as chairman of a powerful committee in this legislature, or as general counsel, or it was chairman of the Criminal Justice Commission, to be able to effectively advocate for policy changes that may need to be made within the branch. Is that fair to say?
To be clear, I don't see it as a bully pulpit. I see it as an opportunity to allow the branch to better fulfill its mission of providing efficient, open and efficient access to the courts for the remedy of grievances. And I think is obviously a vital role in a orderly society, and so trying to do that in a constrained environment is becoming more challenging. As I said in my opening statement, the men and women who are fighting on the front lines every day are trying their very, very best and accomplishing some great advancements with very, very limited resources available to them.
I want to switch gears, and I want to ask you about a conversation you had earlier today regarding a bill you sponsored or I guess proposed when you were state legislator, SB 1098. You were asked some questions by, I believe it was Vice Chairman McLaughlin earlier, about what you said back in 2013.
Congratulations.
And all good. And you seem to struggle recalling exactly what you said during your testimony in 2013. So I was able to, during the time, pull the transcript here, and I wanted to read back to you what you said in 2013 and see if that is still your recollection today or whether it has changed in any way. You were asked at the time by Senator McLaughlin, it was understood by me that you were the author of Senate Bill 1098, but I'm sensing from your presentation to us today that you were carrying the ball of language presented to you from someone else. Could you clarify for me? And your response was the legislative proposal that was presented was furnished to me by a gentleman by the name of Tom Gallagher. You continued down talking about how he came to you, and oftentimes you get proposals from constituents. And you finished by saying, it's an imprecise process, but specifically to the question that you asked, Senator, the legislative proposal was furnished to me by Mr. Gallagher. Do you stand by that testimony that the idea for the legislation was furnished to you by Mr. Gallagher?
I think my testimony today is consistent with that statement, yes.
I've read through the testimony. I didn't see any place in your testimony in 2013 where you said you authored the legislation or that you wrote the legislation. I believe the only thing you ever said was that you furnished that the proposal was furnished to you by Mr. Gallagher. Is that
That's and as I said, it was furnished to me by Mr. Gallagher, and I handed it off to an LCO attorney to convert it into the legislative talk, if you will.
Okay. And I believe you covered this earlier, but you, I believe you call, obviously this is probably technical for our purposes, but that SB 1098 in session year 2009 was a raised bill. It was introduced by the committee as a whole as a raised bill. I know you had some confusion about that. I've had a chance to go back and check the record. I'm wondering if you recall the process for raising a bill before a committee of the General Assembly, whether it needs to be voted on by the full committee or whether the chairs have the prerogative just to, on their own, raise a bill.
Well, to be clear, I don't know if it's changed from the time that I was in this room. When I was here, we would pretty much at the organizational meeting, I think, ask anybody with proposals, including some that I found not to my liking, let's say that. If people had concepts that they wanted to raise, it was pretty much an open door, and all you needed to do was tell us the concept, and we would put it onto an agenda, and we would vote. I think it was voice vote. I think it was a voice vote to raise the concepts. And then once the concepts were raised, then the LCO attorneys would get to work with whoever was interested in that concept to start drafting the legislation. But yes, it was a vote of the committee. It was not a determination by the co-chairs.
Right. And I've pulled the vote on that to raise that bill was a vote of 37-0 by this committee. There was, and it doesn't indicate it was a voice vote. We see that sometimes, but there's actually, if you go back and you pull the legislative history, there's a tally sheet, and the final vote was 37-0 to raise that bill. So is it fair to say it was not a unilateral action on your part to raise that bill, that it was.
No, to be correct, it was not, and to be fair, it was a title to a bill. It was not a full, I mean, that's just, I don't need to educate you folks. That's just the way the process is. Every year there's a bill, an act concerning court operations. Well, that could be anything, but it's just a title to initiate a process by which discussions can start to happen. But yes, it was a vote of the committee.
I want to ask you a couple questions about this notion of your relationship to the governor and also your prior government service, and whether that creates a disabling conflict of interest for you or not. I wasn't here 5 years ago. Were you asked those questions? Were you asked about that at the public hearing for your nomination to be an associate justice of the Supreme Court in 2013?
Absolutely.
Governor Malloy was still governor then, correct?
Correct.
You were just leaving the general counsel's office, correct?
I was still in the governor's counsel's office when I was before this committee. I've gone back and I've looked for some precedent to figure out if there is any precedent for someone who is on the Supreme Court or is being considered for appointment to the Supreme Court, whether their relationships with high-ranking government officials creates a disabling conflict for them. And I found a couple examples. The first was actually President Nixon appointing his then high-ranking official in the Justice Department, William Rehnquist, to be Justice of the Supreme Court. The other one I found that was interesting was Justice Scalia. I think it's no secret to anybody that Justice Scalia had a very close personal relationship with then Vice President Cheney. And there actually was sort of an issue back in 2004 where the Sierra Club actually challenged Dick Cheney. It's challenged then Justice Rehnquist's ability to sit on a case that involved whether Justice Scalia, let me rephrase that. There was an issue in 2004 where the Sierra Club questioned whether Justice Scalia should sit on a case that involved whether then Vice President Cheney had improperly withheld notes and had private meetings of his energy task force in 2001. It came out that about 3 weeks after the Supreme Court agreed to hear the case, then Vice President Cheney went duck hunting with Justice Scalia. The Sierra Club moved to disqualify Justice Scalia from hearing the case, and Justice Scalia wrote a 21-page memorandum outlining why he should not have to recuse himself from that case involving Dick Cheney. He wrote at the time that he would have an obligation to recuse himself if the personal fortunes or freedoms of a friend were at stake, but not if the issue was a friend's official action, as he argued was the case here with Mr. Cheney. Would you agree with that statement? I would, and I have. Well, let me say I have not read the statement you've shared with me. I would agree with it. I think it is very consistent with the memorandum decision that Justice Rehnquist issued when a party moved to disqualify him because he had testified before Congress about the constitutionality of a proposal in Laird versus Tatum. And he went on at length, I don't know if it was 21 pages, but he went on at length to say that though he had previously testified in a governmental capacity about the constitutionality of a proposal, it did not preclude him from sitting on the merits of the exact same legislation when it came before the court. And I think it is a question of whether or not you can separate in your mind the duty that you have, the oath that you have taken to be fair and impartial with your life experiences. And I think it not just in the situations you've talked about, but it happens for judges all the time where they are called upon to make that determination.
Let me ask you this directly. If Governor Malloy's personal fortune or freedom were at stake in a case before the Connecticut Supreme Court, would you recuse yourself or disqualify yourself from sitting on that panel?
I would. In fact, when I was here in 2013, I went further than that. Not that it would be his fortune or his freedom, but any case where he was named in his official capacity as governor or in a personal capacity, I would have recused myself, and I have done that.
Okay. Justice Scalia continued in that memorandum. A rule that required members of this court, meaning the U.S. Supreme Court, to remove themselves from cases in which the official actions of friends were at issue would be utterly disabling. Care to comment on that?
I think the opinion speaks for itself. I should say it's consistent with the Sixth Circuit's decision in Buell versus Mitchell.
There are previous examples of government officials who've worked on particular legislation or particular issues continuing to sit on cases involving that legislation or issues, correct?
Yes, actually, in the treatise that I talked about before, there's an example where then Senator Hugo Black authored and wrote the Fair Labor Standards Act, and then when he sat on the U.S. Supreme Court, he ruled on the constitutionality of that act. Felix Frankfurter, when he was a law professor at Harvard University, had a principal role in drafting the Anti-Injunction Act, and then when he was on the court, ruled on the constitutionality of that act as well. And Justice Rehnquist goes in his opinion in Laird versus Tatum, makes similar parallels not only between Justice Frankfurter and Justice Black, but also in Justice Jackson, Chief Justice Hughes, and several other members of the court to similar effect.
So
I should say, not just in that. I think it was, I can't remember who it was. I thought it was Hugo Black. Used to play poker with FDR in the White House, and would sit on cases. I think it was Justice Black would sit on cases on the Supreme Court regularly, obviously, where the administration was bringing cases before the court.
So I guess all this to say, you're not the first judicial nominee to be in this position, correct?
That's fair to say, and it requires every judicial official to be vigilant.
And I guess as I've sat here most of the day today, and I've listened to you discuss case after case, and why you ruled a particular way, or why you felt the court's authority was constrained in particular ways. We talk about this a lot from up here, that a judge, any judge, is a product of their experiences. And one of the experiences you bring to the Supreme Court is your experience having been a member of the state senate and a member of the administration? You were asked earlier how many people have served in all three branches of state government, and it's not a whole lot. But I think one of the things when we talk about judicial activism, or we talk about separation of powers, or we talk about the proper role of the court, is recognizing those lines. And I think one of the cases you've cited a couple times today is the State versus Skipworth case, where, again, you made it very clear in that decision what the role of the legislature was in enacting an enforcement mechanism and what the role of the court was in adjudicating around those. So I'm wondering how your experience as a former state legislator, as somebody who sat on this side of the dais, and as somebody who sat, in the other building down the hall from the governor, comes into play as you sit there and exercise judicial restraint in deciding whether the court should push the bounds a little bit or not.
Well, I mean, I'm not going to rehash what I've said. I believe strongly, deeply about the unique role of every single branch of our government, and there are times when many of our roles come close to intersecting, if not colliding. And we have been very fortunate, I think, in this state to be able to navigate those issues in a collaborative fashion. I know when I was on this committee, we had spirited debates with the judicial branch about the rules of practice and whether the legislature had a role in that, or if it was a judicial function. And we had a lot of different issues. I'm not going to. The hour is late. I'm not going to do it, but we've always had an opportunity in this state. I think it's a distinguishing feature of our relationship and a respect for different branches of government that we've been able to address those issues head on and resolve them in a way that is respectful of each branch's authority and its autonomy. I think, given my experience in all three branches of government, I am very mindful of the prerogatives of each of those branches. The passage of 1-2Z was not something that I thought was only important when I was a member of the legislature. I think it's just as important to me now as a tool of statutory construction on the court. So, I will tell you that my colleagues and I all come from different backgrounds. I have repeatedly been told by my colleagues that my unique experience in public life has been immensely helpful to me, and I can certainly say that about my colleagues, that their unique perspectives have been immensely helpful to me as a judge. And so I know where the lines begin and end. They will. I have to confess, it is very hard sometimes to articulate in any minute detail where they are. But I think all of us strive to the highest ideals, and we all keep each other fair and honest.
Justice McDonald, do you recall the State versus Riley decision?
Yes, I do.
Was that a decision you authored?
It is.
Could you, I don't think we've touched on that one today. Can you explain what that case was about to the panel?
I think I alluded to it very briefly. State versus Riley was a case that was where we were called upon to analyze two U.S. Supreme Court cases that dealt with mandatory life sentences for juveniles. And in the Riley case, there was not a mandatory life sentence, but it was a discretionary sentence and the court, using its discretion, sentenced the defendant to a term of 100 years in prison. And so the question before us was whether the principles from the U.S. Supreme Court cases would apply in that circumstance. And we determined that, in fact, they would apply in that circumstance, and that the defendant needed to be resentenced, considering the development of a young adult. I think he was 16 at the time he committed the crime. What the development of a young adult's brain might be at that time. We were asked to also fashion a remedy at that time for a violation of that constitutional right. And because it was going back for resentencing, we considered the remedy a premature, not ripe issue. It was not. It did not need to be decided for us to resolve the case, and so we rejected that request for two reasons. Well, the first was what I just said. It was going back for a new trial anyway, and the second was because we knew that the legislature had before it a piece of legislation, I think it was for the third year in a row, that was being advocated by the Sentencing Commission to deal with what is, in short terms, has been termed the second look of what would happen for somebody who is a juvenile and sentenced to a long period of incarceration. And I don't remember exactly what I said in the Riley case, but it was effectively that out of due deference for the prerogatives of the legislature, we would stay our hand in deference to the legislature because they had ongoing legislation, and I think the opinion effectively says the legislature is in a better position to evaluate the contradictory policy goals and objectives, even though we theoretically would have had the opportunity to fashion a remedy for a constitutional violation because it was premature and because the legislature was actively debating that issue. We did not act in deference to the legislature, and ultimately, as you probably know, such a piece of legislation was passed and signed by the governor.
Your memory's pretty good there, Justice McDonald. Your exact quote was, "Staying our hand in deference to a coordinated branch of government is particularly appropriate in the present case," and you went through to explain how the matter was before the Connecticut Sentencing Commission, and there was legislation drafted, and this committee ended up in 2015, in the wake of your decision in State v. Riley, finally acting on that legislation, which became Public Act 15-84. Again, following that decision, and I believe a companion decision in a similar case as well.
Cassiano.
Right. Justice McDonald, just one final question for you. I don't think anybody's asked you this yet either. Why do you want this job?
As I indicated in my opening statement, the opportunity to serve the people in this role would be a unique and profound one. There have been, I'm certain I'm biased here, but I have seen models of how courts around the country are constituted. A lot of courts are elected. I think 38 courts of last resort are elected in their states. If there has been a concern about a moment of discontent or perhaps intemperate language used in one or two of our cases, it pales in comparison to many states where judges are elected. There have been fights in some courts. There have been members suspending other members. I mean, it runs the gamut. I think we should be particularly proud in Connecticut about our tradition of how the court is appointed and confirmed, and how more importantly how the court operates. It is, as I said earlier, it is devoid of ideological divide. If you look at the lineup of judges in any particular case, we are all over the map, and I think that's a good thing because everybody is approaching it. It's not like you read in Washington where it's 4 on one side and 4 on another, and there's a jump ball in the middle. We don't have that in Connecticut, and I think we should be proud of it. I know more generally than just the court, I know that the men and women of this branch of government work day in, day out, trying to advance the interests of the people of Connecticut under very trying circumstances, and they do a remarkable job. Losing my voice. And they do a remarkable job, and the opportunity to assist them in the discharge of those responsibilities would in fact be the height of my professional and public career.
Thank you, Justice McDonald.